Greetings, students. Today's topic of the day for the subject Legal and Constitutional History is Judicial Reforms of Lord Warren Hastings. And underneath the jurisdiction of Lord Warren Hastings, we also tend to see what are the reformative changes that were brought about by the Judge Lord Elijah Impey. So today's topic of the day will all be about this. And this is particularly meant for the students BA-LLB 3rd Sem. So, Lord Hastings brought certain reformative changes in the judiciary system of then the government in the year 1813. Lord Hastings took up the charge for the British government in the year 1813. He was a shrewd, patient, and independent man. He adopted more liberal and sympathetic policy towards Indians and introduced certain important reforms in the administration of justice. During the regime of Hastings, effective steps were taken to modify the basis of Cornwallis systems. However, the position was that the judges of Diwani Adalats were overburdened with the work, resulting in areas of undecided civil and criminal cases, facilitating some change to expedite the course of justice. Hastings did not favor the idea of increasing the number of courts presided over by Europeans on the economic grounds. So, he did bring certain changes, and those particular reforms introduced in the civil judicatures are: number one, courts of munsifs were increased in number, and the pecuniary, which means little or meager jurisdiction or little jurisdiction, was raised to rupees 150, or the amount was raised to rupees 150. Rules of procedures were laid down or written down. The pecuniary jurisdiction of Sadar Adalats was increased from rupees 100 to 150 in original suits referred to them by Zilla or city judges. An appeal was allowed to the city judge whose decision was final. So, the verdicts given by the city judges were considered to be the final justice. Number 3, the courts could not entertain any suit when the British subject was a party. Number 4, in 1821, the Sadar Amins were empowered to take suits up to rupees 500. In 1841, the registrar was authorized to decide original suits referred to them by Zilla and city judge up to the value of rupees 5 OGO. The number of judges of each provincial court was increased from 3 to 4. All their decisions were rendered appealable to the Sadar Diwani Adalat. Number 6, in 1813, the Provisional Court and the Sadar Diwani Adalat were made competent to admitted to second appeal. So the whole criteria of second appeal was introduced here in the Sadar Diwani Adalat. And lastly, criminal jurisdiction. Native law officers or local law officers and Sadar Amins were given criminal jurisdiction in 1821. Magisterial power were given to collectors of revenue. Collectors of revenue मतलब जो tax collect करते थे in the year 1824 to ensure efficient realization of revenue itself. The jurisdiction of magistrate was enlarged. So, what we tend to see is that Lord Hastings approved the suggestions of employing more Indians in the administration of justice and increasing their judicial powers. Administration of criminal justice suffered to a great extent due to exclusive employment of Europeans as judges to hold criminal trials. They consumed a lot of time in reaching a decision because of the ignorance of the Indian people, their habits, traditions, and usage. Now, we will see the whole changes brought about by Lord Elijah Impey. Elijah Impey was appointed as a sole judge of the Sadar Diwani Adalat. Governor General and the Council admitted that their incapacity to exercise the power and expressly stipulated that Chief Justice Sir Elijah Impey should he be the sole judge of Sadar Diwani Adalat. They thought that this would lessen the tension between the council and the court itself. So, of course, Elijah Impe played a very important role in bringing a very considerable change, being the Chief Justice of the Sadar Diwani Adalat. The Governor General and the councils were non-lawyers. Impe was rather a very experienced and a trained lawyer and was expected to discharge judicial function in a much better way. So, if we look at the situation then, before Elijah Impe was introduced as the judge of the Sadar Diwani Adalat, the Governor General and the Council had no time to sit for the Diwani Adalat courts or to hear appeals and supervise the work of the court. So, without the support and the control of some powerful authority, it was impossible for them to subsist, as there were only 6 Diwani Adalats. The Zamindars as public officers were acting as honorary judges. There was a danger of abusing the authority to their own advantage. And thus, the Governor General and the Council felt that a very competent man who was experienced in the domains of law and who was a trained lawyer should be introduced into the system, who would bring a very dynamic and prolific change, and thus Sir Elijah Impe was introduced. Now, we'll see the judicial reforms that were brought about by Lord Elijah Impe. So, in the fulfillment of his new duties, Impe had prepared 133 articles of regulations for the guidance of civil court. They were afterwards incorporated in a revisited code consisting of 95 articles. This code was passed in July 1782. This was the first civil procedure code of India. Impe, in his plan of 1781, hit at the evils of existing system. Appeals from a decision of Diwani Adalat, if its value exceeded rupees 1007, were taken to Sadar Diwani Adalat. Impe retained the separation of executive with the judiciary. In order to check the irregular practice of the administration of justice, Impe that no judge of the Mufasal Diwani Adalat should leave the questions of fact to the determination of native law officers or the person. He said that all those facts and every problem must be settled by the judge himself. Impe filled up the gap by providing that all the cases for which non-specific directions were given, the Sadar Diwani Adalat and the Mufasal Diwani Adalat were to act according to the justice, equity and good conscience. This remarkable provision helped to give decisions to all civil cases of Hindus and Mohammedans. So, he always looked at a good conscience of a decision where there should be equity, where moral values were upheld, and no forms of disparity should be entertained by any form in the judicial system itself. Another important reform of Impe was that Sadar Diwani Adalat was put on a sounder basis. He brought the union of powers of the Board of Supervision with those of the Court of Appeal. This code was an extraordinary one. He had given new direction to the judges of Diwani Adalat and litigants. It was the first attempt of its kind in India to make CPC certain to some extent. So, these are the judicial changes or the reformations that was brought by the Governor General Lord Warren Hastings and Lord Elijah Impe, who tend to be the Supreme Judge of Sadar Diwani Adalat, because he was the one who formed the monumental basis for the CPC that we tend to study, that we tend to have in the Indian judicial system. That was the first step taken by the man himself. So this will be it for today class. Thank you.